Hello friends, in the series on the income tax cases, today we will discuss a very important issue on section 263 revision proceedings. The issue before the Honorable Punjab and Haryana High Court in the present case was that whether the Principal Commissioner of Income Tax has the power to revise an assessment order which has merged with the order passed by the Tribunal. The matter has been decided by Honorable Punjab and Haryana High Court in the case of Commissioner of Income Tax versus Valco Industries Ltd, and this case is reported in 476 ITR at page number 677, and the date of the judgment is 17th July 2024. The facts of the present case are very interesting, and this case is also a perfect example that in the income tax proceedings, no one knows that what can happen to an assessee or a professional because of the misapplication or misunderstanding of the income tax provisions by the income tax authorities. The present case relates to the assessment year 13-14, and in the present case, the assessee claimed deduction under section 80 IA at the rate of 100% for the assessment year 13-14. This deduction of 100% was claimed in respect of substantial expansion done by the assessee in the assessment year 2009-10, and the assessee was claiming 100% deduction from the assessment year 2010-11. The assessing officer issued notice to the assessee under section 148 by recording the reasons that the assessee has claimed in wrong deduction at the rate of 100%, and the deduction should be at the rate of 30%, and accordingly completed the assessment by restricting the amount of deduction claimed by the assessee to 30%. The CIT appeal also upheld the order of the assessing officer. When the matter came to the tribunal allowed the appeal of the assessee and directed the AO to allow the assessee to claim the deduction under section 80 IA at the rate of 100%. After that, the Principal Commissioner of Income Tax did revision under section 263 by saying that the deduction under section 80 IA is allowed only up to the 30% and not at the rate of 100%. The assessee plea was that the assessment order has merged with the order of the tribunal. The assessing officer has passed the order with the direction of the tribunal direction. So in that case, the Principal Commissioner of Income Tax do not have any power to review the order of the tribunal. But the Principal Commissioner of Income Tax was not convinced with the contention of the assessee, so he go ahead with disallowing the deduction at the rate of 100%. When this revision was done, the assessee filed the appeal before the tribunal, and the tribunal said that in the present case, once the tribunal has passed the order, then the Principal Commissioner of Income Tax do not have the power to revise that order, because assessment order, when appealed and merged with the tribunal order, that cannot be revised. The tribunal in the second round of litigation was of the considered view that if this type of revision will be allowed, then it will tantamount to against the principle of merger, judicial discipline, and principle of res judicata. The tribunal said that the Principal Commissioner of Income Tax do not have the power to review the tribunal order indirectly by invoking the provisions of section 263, and the tribunal said that every litigation must attain finality, and if this type of revision will be allowed, then there will be endless litigation. So friends, from the conclusion of the case, it comes out that once the assessment order is merged with the order of the tribunal, the Principal Commissioner of Income Tax loses its right to revise that order. At the end of this video, once again I am repeating the name of the case. The name of the case is Commissioner of Income Tax versus Valco Industries Ltd, and this case is reported in 476 ITR at page number 677, and the matter has been decided by Honorable Punjab and Haryana High Court on 17th July 2024. Thank you, friends.